In Texas, property is sacred. But that didn't stop my HOA from bulldozing my pasture and calling it community progress. You won't believe what I saw that morning. The sun had barely lifted over the pecan trees when the low rumble of engines rolled across my pasture. I stepped out onto the porch, coffee steaming in my hand, boots still half-laced, and there they were. Bulldozers, graders, a full construction crew tearing up the grass I'd planted myself 15 years ago. At first I thought maybe the county was doing ditch work, but as I walked closer I realized something was off. No county logos, no official trucks, just orange safety vests with the letters LMHA stenciled on the back. The Lakeside Meadows Homeowners Association. That name alone made my stomach tighten. Their subdivision sat about a half-mile down the hill. Neat lawns, white fences, identical mailboxes. A world away from the dust and freedom of my 40-acre ranch. And now, apparently, they had decided to build a road through it. I flagged down the foreman, a sunburned man chewing on a toothpick, standing beside a roaring excavator. "Morning," I said, trying to keep calm. "You all realize you're on private property, right?" He shrugged. "Sir, we're just following plans from the HOA board. This is the Lakeside Extension, supposed to connect to County Road 214. 214? I repeated. "That's on the other side of my north fence line." He pointed toward my cattle pasture. "Yep, that's the one." I laughed, not because it was funny, but because I couldn't believe what I was hearing. I said, "You're standing on private land, my land." He looked uncomfortable, kicked at the dirt, and finally muttered, "Talk to the HOA president. She said everything's approved." And then he waved his arm, and the bulldozers kept moving. That night, sleep didn't come easy. The sound of diesel engines still echoed in my ears. So I went digging, literally and legally. I pulled out the old survey maps from 1987 when my father transferred the ranch deed into my name. Then I logged into the Oak Ridge County property portal and compared parcel numbers. Sure enough, the HOA's new road cut 70 feet into my boundary line, right through what used to be my south pasture. The deed was crystal clear. Lot 72A, McAllister Ranch, 40.02 acres, granted and recorded, Book 1452, page 311, March 1987, under Title 8, Chapter 22 of the Texas Property Code. Under that same law, no entity, not even an HOA, may seize or alter private property without written consent or a filed easement. I'd never signed an easement. My father hadn't either. The county recorder's office confirmed no easement ever existed. So how did this HOA think it could just plow through? The next morning, I called the HOA president, Linda Carson. If arrogance had a voice, it would sound exactly like hers. "Mrs. Carson," I began, "your contractors are building across my pasture. They've gone 70 feet inside my property." A long pause. Then, in a tone dripping with condescension, she replied, "Mr. McAllister, that strip of land was meant to serve the community. It's part of an easement your father agreed to when Lakeside Meadows was first planned." I frowned. "Ma'am, my father never agreed to any easement. He died before Lakeside Meadows even existed." She sighed. "Well, we have old survey documents that suggest the area was designated as community access." "Show me those documents," I said. "I'll have our lawyer send them," she replied and hung up. Days turned into weeks. No documents, no letters, but the roadwork continued, louder, deeper, more permanent. They poured gravel, set drainage pipes, even installed stakes labeled Future Sidewalk Boundary. I watched from my fence line, fists clenched. Neighbors started stopping by too. "John, what's all this construction?" asked Earl Jenkins from 2 farms over. "HOA nonsense," I muttered. "They think they can build a road through private land." Earl shook his head. "They tried that same thing on my cousin in Denton County, claimed they had a prescriptive easement. You better shut that down before it's too late." He was right. Under Texas Civil Practice and Remedies Code, Section 16.026, if someone uses your land openly for 10 years without your permission, they can try to claim rights through adverse possession. And that was exactly the kind of trap HOAs loved to exploit. So I called my lawyer, Rachel Dean, a property attorney from Waco. When I explained the situation, she didn't sound surprised. HOAs push boundaries all the time, but Texas is a strong property rights state. If they don't have a recorded easement, they're trespassing under Penal Code 30.05. She advised me to gather evidence: photos, maps, witness statements. By that evening, I had a file thick enough to choke a bull. I sent it all to her office. She promised to draft a cease and desist notice to the HOA within 48 hours. The following Monday, I walked back out to the construction site with a printed copy of the notice in my hand. The crew was still there. I handed the form in the paper. "Show this to your boss," I said. "You're trespassing on private property under Texas law." He glanced at it and shrugged. "I just work here, sir." A few of the workers started laughing. One shouted, "Guess we'll see who owns it when the pavement dries." That's when I realized this wasn't a misunderstanding. It was entitlement. That night I stood by the porch fence, watching the floodlights from their worksite flicker across my pasture. Every bucket of dirt they moved felt like they were taking a piece of my family's history. The land my father built, the land my kids grew up on. I thought about all the stories you hear: small homeowners bullied by HOA boards, fined for grass length or paint color. But this was something else. They weren't just telling me how to live, they were trying to take what was mine. I drove to the Oak Ridge County Recorder's office the next morning. A kind woman named Deborah helped me pull every historical plat and subdivision map within 2 miles of my ranch. As we spread the papers across the counter, she pointed to a line highlighted in yellow. "That's the Lakeside Meadows boundary," she said. Then she tapped another line, my property edge. "See that gap? 70 feet between the two. That's still your land." "Then why are they claiming an easement?" I asked. She gave a tired smile. "Because most people don't check. They assume the HOA knows best." But I wasn't most people. I asked her to certify copies of every record. By the time I left, I had a folder stamped with the county seal, "Solid proof." When I got home, I noticed fresh tire tracks cutting deeper into the pasture. They'd expanded overnight, pouring concrete forms and installing rebar. They were racing to finish before I could stop them. So I did something drastic. I parked my tractor right across their unfinished lane. A 9,000-pound message that said, "Not another inch." The foreman came running. "Sir, you're obstructing construction." I smiled. "You're obstructing private property." We stood there, two stubborn men in the Texas heat, neither willing to back down. Finally he muttered, "You'll be hearing from the board," and stormed off. That evening, I finally got the email from Linda Carson. A scanned document labeled Historic Access Map, 1995. I opened it and almost laughed out loud. The map was a hand-drawn sketch with no coordinates, no surveyor stamp, nothing legally binding. It might as well have been drawn with crayons. At the bottom, in faded ink, someone had written, "Future Service Trail," to connect Ranch and Lakeside Drive. That was their evidence, a doodle. Rachel Dean later told me it was worthless in court. No official record, no county acknowledgement, no signature from any McAllister. But the HOA was betting I'd fold before it got that far. For weeks, I lived in a kind of limbo. Coffee gone cold, phone buzzing nonstop, the distant whine of machinery cutting through my fields. Every morning, I'd ride my ATV out to the edge, checking the stakes, taking photos, documenting everything. Neighbors started whispering. Some took the HOA's side. They wanted the shortcut road to town. Others backed me, saying, if they can do it to him, they can do it to any of us. By the end of March 2022, my ranch looked like a battlefield. Half-built road on one side, fences ripped apart, tire marks in the mud, and I hadn't even begun to fight yet. The moment that sealed it came on March 28th. I came home from feed supply to find one of my fences knocked clean down, posts splintered, barbed wire coiled in the dirt, and a shiny new, road closed, community construction sign planted right in the middle.
They'd replaced my fence with their sign. That's when I decided enough was enough. I took out my phone, hit record, and said the words that would start a year-long war with the HOA. This is my land. You built a road through it without my permission. And now you're going to see what Texas property law really means. When I hit record that March evening, I didn't know the storm I was inviting into my life. The video of me standing in front of that illegal road, dust swirling around, boots caked in mud, spread faster than wildfire across Oak Ridge County Facebook groups. By morning, my phone wouldn't stop buzzing. Messages, comments, calls from numbers I didn't know. Half the people cheered me on. "You stand your ground, Mr. McAllister. Don't let those HOA crooks take what's yours." The other half called me a selfish old rancher blocking community progress. But progress isn't progress when it's built on stolen dirt. The next week, on April 3rd, I took action. I walked out to the south edge of my property, where the illegal road split through my field like a scar, and began rebuilding my fence, post by post, wire by wire. Every hammer strike echoed across the open air like a challenge. By sundown, a 6-foot metal fence stretched across the so-called lakeside extension. I hung a wooden sign in the center that read, "Private property. Trespassers will be prosecuted under Texas Penal Code Section 30.05. For the first time in weeks, I felt peace. The line was drawn. Literally. That peace didn't last 24 hours. The next morning, a white USV pulled up. HOA plates, tinted windows. Out stepped Linda Carson, the HOA president herself, wearing high heels and a blazer far too clean for the Texas dirt. She stood there, squinting at my fence like it was a personal insult. "Mr. McAllister," she called out, "this fence violates community access rights." I walked towards her, wiping sweat from my brow. "Community access? This is a ranch, not a playground." She crossed her arms. "This road was approved by the board to connect lakeside residents to County Road 214. Your fence is interfering with that plan." "Good," I said. "That's the point." Her jaw tightened. "You're in direct violation of Lakeside Meadows Association bylaws, Article 7, Section 3, which prohibits obstruction of common easements." I almost laughed. "That bylaw doesn't apply outside your subdivision. You're on private land. That code has as much authority here as a traffic ticket in Mexico." Linda's smile turned sharp. "We'll see about that." She took photos of my fence, my property signs, even my truck's license plate, then got back into her SUV. When the dust from her tires settled, I knew one thing for sure. This was only the beginning. 2 days later, a certified letter arrived. Stamped in bold, "Notice of Violation, Lakeside Meadows HOA." It accused me of blocking community access to approved common areas and damaging HOA infrastructure. They demanded I remove the fence within 72 hours or face daily fines of $250 under Texas Property Code Section 209.06. Imagine being fined for defending your own land. Rachel Dean, my attorney, nearly laughed when she read it. She said, "HOAs love sending these, but they're meaningless outside their jurisdiction. It's intimidation, nothing more." Still, she suggested we reply formally. That afternoon, we sent a certified cease and desist letter of our own, citing the Texas Transportation Code Section 25117, which forbids any private entity from building or maintaining a public road without county authorization. We attached copies of my deed, survey maps, and photographs of the encroachment. The message was clear: stop construction or face legal action. But the HOA didn't stop. Instead, they escalated. By mid-April, the residents of Lakeside Meadows had turned me into a villain on social media. Posts accused me of landlocking the neighborhood and endangering children who use the road to bike to school. One comment even said, "If he wants a war, the HOA has lawyers." And they weren't bluffing. On April 15th, I came home from the feed store to find 2 sheriff's deputies parked at my gate. One of them, Deputy Morales, a decent guy, looked uncomfortable as he handed me a document. "Temporary restraining order," he said quietly, "filed by Lakeside Meadows HOA." I opened it right there on the tailgate. It claimed my fence caused irreparable harm to the community's right-of-way and ordered me to cease interference until a hearing could be held. I asked Morales, "Do they have proof it's their land?" He sighed, "That's for the court to decide. Just don't take the fence down yet. Let it play out." He meant well, but I could tell even he thought it was ridiculous. That night, I sat at the kitchen table, paperwork spread everywhere. My hands shook, not from fear, but from anger. I had done everything right, checked records, filed notices, followed the law. Yet somehow I was the one being treated like the criminal. I stared out the window toward that fence, glinting in the moonlight, and swore I wouldn't back down. The next morning, I found tire marks leading right up to the fence. Someone had rammed it during the night. The posts were bent, one section torn clean off. Near the damage lay a sign, white, fresh paint, reading, "Community Road, do not block." That was it. No signature, no note, just defiance. I called Rachel immediately. She said, "Document everything. Photos, timestamps, sheriff's report. This just turned from civil to criminal mischief under Texas Penal Code Section 28.03. Within the hour, Deputy Morales was back, shaking his head. "Looks like someone took matters into their own hands," he said. He filed a report but admitted catching the culprit would be near impossible. Meanwhile, the HOA doubled down. They started holding emergency meetings about me, claiming I was hostile, unreasonable, and threatening their members. One neighbor forwarded it to me. It ended with, "Our board will pursue all legal remedies necessary to protect lakeside interests." They were painting me as the villain in their suburban fairy tale. But I had something stronger than their narrative. I had facts. By the end of April, the situation hit boiling point. Rachel filed a counterclaim in court. Trespass to real property, Texas Civil Practice and Remedies Code, Section 125.002. Property damage, fraudulent construction activity without permit. We demanded an injunction forcing the HOA to remove the road and compensate for damages. The courthouse clerk, a gray-haired man named Carl, smiled when he saw the paperwork. "Another HOA case?" he said. "You wouldn't believe how many of these I see every month. Good luck, son. They play dirty." 2 days later, as if to prove his point, the HOA's attorney sent me a settlement offer. $10,000 in exchange for a permanent community access easement across my pasture. $10,000 for land my father bought with 40 years of sweat and sacrifice. I didn't even bother replying. Instead, I took that same letter and nailed it to my fence post right beside the private property sign. The fence war, as locals started calling it, divided Oak Ridge County. Some residents put up "Stand with McAllister" banners. Others put "Open the Road" signs in their yards. It became more than just a property dispute. It was a symbol of how far HOAs would go when they thought power made them right. Local news even picked it up. Rancher battles HOA over unauthorized road construction. Linda called it misinformation. I called it the truth finally catching up. On April 29th, something unexpected happened. The county commissioner's office contacted Rachel. Turns out, the HOA never filed a construction permit for the road, meaning every inch they'd built was illegal under Texas Local Government Code, Section 232.001. The county issued a stop work order, effective immediately. When I saw those county trucks roll up and tape that bright orange stop work notice across the gravel, I felt something I hadn't in months: hope. The foreman refused to look me in the eye as his crew packed up and left. But Linda wasn't done yet. That same evening, she posted an HOA update online claiming the county has temporarily paused construction for paperwork review. Mr. McAllister's fence remains in violation. No apology, no admission, just spin. I stood by the fence that night listening to the crickets and the hum of the wind through barbed wire. It wasn't over, not by a long shot, but for the first time I wasn't alone. The law, the county, and half the town now saw the truth. The HOA had overstepped. They could write fines, they could post letters, but they couldn't erase ownership. I ran my hand along the rough metal of that fence, whispering to myself, "This line stays, no matter what it costs." Little did I know, the cost would be more than I imagined, because next they were about to drag me into court. Things escalated fast, faster than I ever imagined. By the time June rolled around, the situation had turned from a property dispute to a full-on war. What started as bulldozers on my ranch had now evolved into a line of SUVs parked outside my gate every few days, carrying HOA board members, surveyors, and, worst of all, county inspectors. Each visit came with more paperwork, more warnings, and more threats of legal action. It was like the entire HOA had made it their summer project to break me down. I'd see them standing on the dirt road they'd built, clipboards in hand, pointing toward my barns and pastures as if they owned the place. They'd whisper to each other, take photos, and leave. Then one morning, I found a bright yellow envelope taped to my fence post. It was a temporary restraining order, filed against me. Oak Ridge County Court, case number 2022 CV 1047. The Lakeside Meadows Homeowners Association versus James McAllister. The HOA claimed I was interfering with public right-of-way and causing irreparable harm to community access. I couldn't believe it. They were suing me for blocking my own land? That evening, I sat at my kitchen table, the restraining order spread out beside my coffee mug. I called my attorney, Rachel Dean, a sharp, no-nonsense property lawyer out of Dallas. She listened quietly as I explained everything: the bulldozers, the road, the fence cutting, the threats. When she finished, she said, "James, this isn't just arrogance. This is trespass wrapped in bureaucracy." "Can they even do this?" I asked. She said, "Not legally, but they're betting on intimidation. Most property owners give up before it gets this far." Rachel came down to Oak Ridge the next morning, and we started digging into the county's public records. And that's when we discovered the truth, and it was uglier than I thought. There was no record of any county approval for the road extension, no environmental clearance, no public notice, nothing. The HOA had acted entirely on their own. They'd filed internal minutes claiming the road connection was approved during a board meeting in November 2021, citing community safety and access for emergency vehicles. But under Texas Local Government Code, Section 212.004, any road extension must be reviewed and approved by the local county commissioner's court, not by an HOA vote. Rachel leaned back in her chair and said, "James, they built an illegal road, plain and simple." A few weeks later, we walked into Oak Ridge County Court for the first hearing. The air inside was thick with summer heat and tension. The HOA had brought their entire board, 5 members, all sitting in a neat row behind their attorney. And right in the middle was Linda Carson, her arms folded, that smug look on her face like she already owned the verdict. The HOA's attorney, a man named Stephen Brooks, stood up first. "Your Honor, this is a matter of community access and emergency safety. The HOA has maintained a consistent service trail across the McAllister property for years. An implied easement exists by usage." Rachel stood immediately. Her tone was calm but sharp. "An implied easement? That service trail was a cattle path and the HOA paved over it without consent. Under Texas Property Code, Section 5.026, any easement must be in writing, signed, and recorded. There is none." Judge Harriet Lang, a stern woman in her 60s, adjusted her glasses and said, "Mr. Brooks, do you have the recorded easement document?" He hesitated. Not recorded, Your Honor, but there is historical use." The judge cut him off. "Then there is no easement. Historical use does not grant ownership." Linda shifted uncomfortably in her seat. Rachel continued, "Your Honor, my client has been harassed, his property trespassed upon, and his livestock disturbed, all due to an illegal construction by the HOA." The courtroom fell silent. After a brief recess, Judge Harriet Lang issued her ruling. Temporary injunction granted. Both parties are to cease all construction, maintenance, or interference with the disputed road until the matter of ownership is resolved. I thought that would end it, at least for a while, but I was wrong. The following week, things got ugly. Late one night, I heard my dogs barking like crazy. When I grabbed my flashlight and stepped outside, I saw something glinting in the moonlight. My fence had been cut. Fresh tire tracks led straight across my pasture toward the illegal road. I followed the tracks to the gate, and there it was. A metal sign, freshly bolted to one of my fence posts. Community Road, do not block. My stomach turned. Someone had come onto my land, vandalized my property, and left a message. Not just a warning, but a declaration of control. That's when I decided to take matters into my own hands. The next morning, I drove into town and bought a set of motion-activated security cameras, 6 of them, with night vision and cloud backup. By sunset, they were mounted across the pasture, along the fence line, near the barn, and overlooking the disputed road. For the next few nights, I barely slept. I'd sit on the porch watching the monitors, waiting. Then around 2:14 a.m. on June 28th, the cameras caught something. Headlights. A white pickup truck rolled slowly up the gravel path, the driver's side door opened, and a figure stepped out, wearing a reflective vest. The man walked straight to my fence, cut the wire with bolt cutters, and drove through. The motion sensor light flared on, catching his face for a half second. It was Robert Mills, one of the HOA board members. I couldn't believe what I was seeing. He stopped in the middle of my pasture, got out, and hammered another sign into the dirt, the same one as before. Community Road, do not block. Then he drove back out, through the same cut fence, and disappeared. The next morning, I took the footage straight to Rachel. She watched it twice, silent the whole time, then said, "We're done playing defense." That afternoon, she filed a criminal trespass complaint under Texas Penal Code 30.05 and an additional civil claim for property damage. The sheriff's department sent deputies to take a statement. They reviewed the footage, and one of them said, "This is clear as day. They can't claim community right-of-way for this." Still, Linda Carson didn't back down. The HOA released a letter to all residents of Lakeside Meadows claiming that I was obstructing a vital community access route and endangering neighborhood safety. By July, my name was being tossed around on Facebook groups and neighborhood forums. People I'd never met were calling me a land hoarder and a nuisance to progress. But what they didn't know was that the HOA's illegal actions were finally catching up to them. Rachel filed a counterclaim demanding full restoration of the damaged land, legal fees, and removal of the unauthorized road. Meanwhile, the county environmental department launched their own investigation and found that the HOA's road construction had violated Texas Administrative Code Title 30, Part 1, Chapter 213 regarding water quality protection in rural development areas. The HOA had cut through part of a protected watershed, and that was the nail in the coffin. By mid-July, tension around Oak Ridge County was boiling. Some nights I could still hear cars slow rolling near my gate. I knew.
Linda Carson called me 2 days later. "Mr. McAllister," she said, voice cold as steel, "you've made a very big mistake." "Oh, you mean showing people what your board did?" "You've defamed this community," she snapped. "That video violates our HOA bylaws regarding the use of association images." I actually laughed. "Lady, you trespassed on my ranch. I didn't use your images. I used my cameras." She took a deep breath, then said, "We can still resolve this quietly. Take down the video and we'll drop our complaint." Her voice was calm, but I could hear the panic underneath. "No," I said, "you built a road through private land. You lied to the county. You broke the law. The video stays." Then I hung up. That call was the moment everything shifted. Within a week, the HOA started unraveling. Emails between board members leaked. Someone inside the HOA had sent them to a reporter. Those emails revealed that Linda had approved the road construction without a recorded vote, and that she'd misrepresented the project to both residents and the county development office. One email even said, "Linda, if the landowner finds out we never got the easement signed, this could blow up in our faces." Rachel printed that one and smiled. "This," she said, "is how we end them." Meanwhile, my land was still scarred. The gravel road sat there like an open wound, cutting across my pasture. The fence was patched, the cattle kept wandering near it, and every day that sign, "Community Road, Do Not Block," reminded me that this wasn't over yet. So I decided to make one final video. I stood in front of my ranch gate, the sun setting behind me, the sound of crickets thick in the air. And I said, "This land has been in my family since 1987. My father worked this soil. My kids grew up here. And some HOA thought they could take it because it made their neighborhood more convenient? But property rights still mean something in Texas. You can't bulldoze someone's legacy and call it progress." The video went viral overnight. Over 1 million views in 48 hours. People started calling me the rancher who stood up to the HOA. Support poured in from across the country, letters, emails, even a GoFundMe that I hadn't started, but that people launched to help the rancher fight the system. By late August, national media picked up the story. Fox News ran a segment titled, "HOA Overreach Sparks Backlash in Texas." And when they showed my footage of the road cutting through my land, you could see the comments flood in. "That's illegal. Sue them into the dirt. That man's doing God's work." Behind the scenes, though, Linda wasn't done. The HOA filed an amended lawsuit, now claiming defamation and interference with community governance. Rachel met me in her Dallas office, stacks of paper spread across the table. She said, "They're trying to flip the narrative. They can't win the land case, so they're going after your speech. But the footage is real. Doesn't matter. They'll argue you damaged their reputation." I leaned back in my chair. Good. Let's drag that reputation into the sunlight. The next hearing took place on August 24th, 2022. The courtroom was packed. Reporters, residents, even the county commissioner sat in the back. The HOA's attorney stood first. "Your Honor, Mr. McAllister has publicly humiliated our client by spreading misleading footage." Rachel cut in before he could finish. "Misleading? The footage shows Mr. Mills, a sitting HOA board member, trespassing at 2:14 a.m. We've submitted both video and timestamp metadata. The HOA's claim of implied easement has already been disproven by this court." Judge Lang looked over her glasses and said, "Mr. Brooks, is this true?" The attorney shifted uncomfortably. We can't dispute the footage, Your Honor, but..." "Then this court will not entertain claims of defamation based on factual evidence." And just like that, the HOA's second lawsuit was dismissed. But what happened after court that day shocked me more than anything. As I was walking to my truck, a woman approached me, late 30s, nervous, clutching a folder. She said, quietly, "Mr. McAllister, I'm the HOA treasurer, or I was." I frowned. "You were?" "I resigned this morning. You should see this." She handed me the folder and walked away. Inside were financial records, bank statements showing that the HOA had used association funds to pay for the illegal road construction. Over $128,000 spent without any recorded member approval. Worse, one of the payments was made to a company owned by Linda's brother-in-law. It was fraud, clear as day. Rachel filed a report with the Texas Attorney General's office citing violations under Texas Property Code 209.05, which requires financial transparency for all HOA expenditures. Within a month, the dominoes started to fall. The county issued a cease and desist order against Lakeside Meadows HOA for unauthorized construction. Linda Carson resigned from her position, claiming health reasons.
Robert Mills was charged with criminal trespass and fined. And as for the road, the county ordered it removed and the land restored to its original condition. For weeks, I watched from my porch as bulldozers, the same kind that had once scarred my pasture, now tore up the illegal road, dumping the gravel into trucks and hauling it away. I can't lie. There was a satisfaction in that sound. Every scrape of metal, every load of dirt carried off felt like justice being restored inch by inch. When it was all over, I stood on that same patch of earth where the road used to be. The grass had started to grow back. The fence was fixed, and the only sound was the wind moving through the mesquite trees. Rachel joined me one last time. You know, she said, you could sue for damages, emotional distress, property restoration, maybe even punitive. I looked out across the field and shook my head. I think I've had enough courtrooms for one lifetime. She smiled. You sure? Yeah, I said. I didn't want money. I just wanted my land. That night I posted one final update video. It's over, I said, standing under the porch light. The road's gone, the land's back, and maybe now HOAs across Texas will think twice before bullying the wrong rancher. The comments poured in again. People wrote things like, Texas justice, respect for standing your ground. Every homeowner needs to hear this story. I didn't post another video after that. But even today, every now and then, I still get an email from someone saying, I saw your story and it gave me courage to fight my HOA. And that is worth more than any settlement. Because I didn't just win back my land. I won back the right to say, no one's above the law. The air in October carries a different kind of calm in Oak Ridge County. Cool mornings, quiet nights, and a sense that maybe, just maybe, the land can finally rest. By then, the fight was over. The road was gone. The dust had settled, literally and legally. But the scars, on the land and in my mind, still ran deep. It's strange how something so small, a strip of gravel, a few boards of fencing, can turn into a war that consumes nearly a year of your life. But that's what the HOA had done. They didn't just build a road through my ranch. They bulldozed their way through everything I believed about fairness, law, and decency. And yet, I'd won. Not just for myself, but for every property owner who'd ever been told, don't fight it. You can't win against an HOA. The official ruling came on October 6th, 2022. Rachel and I sat in the Oak Ridge County Courthouse again, just like we had so many times before. But this time, the mood was different. Calm, expectant, like the whole building was holding its breath. Judge Lang entered, holding the final written decision in her hand. She read for nearly 10 minutes. Her words were deliberate, careful, but every sentence felt like vindication. The court finds that the Lakeside Meadows HOA engaged in unauthorized construction on privately owned property without recorded easement, approval, or due process under Texas Property Code 5.026. Furthermore, the association's actions constituted trespass, property damage, and abuse of authority. The HOA is hereby ordered to cease all claims of right-of-way and compensate Mr. McAllister for restoration costs and attorney's fees. When she looked up, she said something I'll never forget. Property rights are not a formality. They are a foundation. This court stands firmly on that foundation. Rachel put a hand on my shoulder and smiled. We did it, James, she whispered. I just nodded, feeling that tightness in my chest finally loosen. After months of chaos, someone, finally, saw the truth. A week later, the county began regrading the land. They filled in the trenches, replanted native grass seed, and hauled away the last of the construction debris. And as strange as it sounds, the sound of those bulldozers this time felt right. They weren't invading anymore. They were restoring. As for the HOA, it practically fell apart from the inside. After Linda Carson resigned in disgrace, half the board quit within a month.
If you've ever faced an HOA nightmare,
or lived through one worse than this, we want to hear it. Share your story in the comments below. It might be the next one we tell. Don't forget to hit like, subscribe, and ring the bell so you never miss the next real-life HOA horror story.